And hello, welcome to the Disability Law Show. John Scholes, Sivan, Tumarkin, and James Fireman back this week. Lots of stuff to get through this week, guys. Reaching out, by the way, anytime, 1-855-821-5900. help@disabilityrights.ca. That is the email address. We'll get to those during the show as well. Plus 5 things you must do ASAP if your LTD benefits are about to be cut off. We'll get to that and lots more. I know, Sivan, you want to talk about a week that was and the pocket employment lawyer. But first, James, you got something to add right off the top, right?
Sure. So one of the things that we like to do every week is give our viewers some information that can help them if they're in the LTD process, whether they're on claim or they've been denied or cut off. And one thing that is of a concern to someone who has been cut off or denied their benefits is what's going to happen to their lives if they start the legal process. And a lot of people are understandably concerned about what that involves, what the time commitment is like, and how much flexibility they'll have in their life choices. And so what you really need to understand is that things in fact get easier once you start a claim. One of the biggest issues people have, especially up to the point where they're getting denied or cut off, is dealing with their insurance company and the adjusters on a day-to-day basis. So the first thing you need to understand is that goes away. As soon as we bring a legal claim and my firm is retained, you no longer are dealing with the insurance company or the adjuster anymore. That's number one. But number two, the focus is always going to be on what's best for you. And so from a medical perspective, you're always going to be listening to your doctor's advice. Right. As a lawyer, I never get involved in the medical decisions. That's always up to your doctor and your medical team. And all you have to do is make sure that we're advised of what's going on. But the decisions are always going to be with your doctor. But the other big issue is people are concerned, well, what happens if I start a legal claim, but 4 or 5 months from now, I'm starting to feel better and I want to go back to work?
Right.
Is that going to be a problem because I have this legal claim? And the very simple answer in every case is no, it's not a problem at all. If you feel better and can go back to work, you absolutely should go back to work. You will do much better financially if you're able to get 100% of your income than trying to recover 2/3 of your income from your LTD insurer. So absolutely, if you can go back to work, you should. And the truth is, if you start a claim and you are in fact able to go back to work, it actually makes it very easy to resolve whatever claim remains for the period of time that you were off. So it's not something that you really need to be concerned about. And in most cases, when you start a legal claim, your life actually gets a lot simpler.
Can you put the claim on ice, so to speak, if you try to go back to work and figured, you know what, I failed, I can't do it?
Absolutely.
Okay.
Absolutely. Although my advice is always, before you decide to go back to work, number one, make sure that your doctor agrees. And number two, make sure that you feel like you're going to be successful. You'll never know for sure. There's never a guarantee. But if you are optimistic, if you feel like there's a good chance that you're going to be able to succeed, then it's the right time to go back.
Sivan, what do you got going on, pal?
So, John, I spoke this week to a gentleman who's 52 years old, and he's a police officer. And it's not the first time that I've spoken with police officers and first responders, firefighters, medics. And, you know, they have extremely, extremely difficult jobs. I have a ton of respect for these individuals. And this particular person called me because he was involved in an armed robbery situation where he responded to that. And, you know, without going into all the gory details of what happened, he suffered, he had a traumatic experience with that. And so he was diagnosed subsequently with post-traumatic stress disorder. And he went on short-term disability, and then subsequently he applied for long-term disability. And he has a psychologist that is helping him. He has a family doctor, and he has a whole slew of other individuals that he's approached in the last year. And despite all of the medical documentation that he's provided to the long-term disability insurance company, they declined his claim. They basically said, we don't have enough or sufficient documentation, medical documentation, to support you being off work, which is absolutely ludicrous. I mean, just on the face of it, you would think from a common sense standpoint, this person has suffered something. Yeah. It's documented. He's on leave from work. He's going to have the support of the department. He's going to have the support of other people, you know, in the unit. It's simply outrageous that they would have declined his claim. So he tried to appeal that decision, and you know, of course, he was denied, and that only added to the stress. And so I spoke with him. I saw some of the medical documents that he's provided. I looked at the denial letter and the denial of the appeal. This is a straightforward case where once we start that legal claim process, I can tell you, I would not be surprised if I get a call as soon as the insurance company gives that claim to one of their defense lawyers. I get a call from their defense lawyer trying to resolve the claim. And so, the lesson out there, not only for first responders, but anybody who goes through a traumatic experience, and it could be a personal loss. It could be that you've lost a loved one. Something is happening, something, that pushed you over the edge. As long as you're following the treatments of the people who are treating you, psychiatrist, psychologist, whoever it is that's treating your family doctor, and as long as they're supporting you being off work, that they say you cannot work and they explain why, you should be approved for long-term disability, and don't waste time with those appeals. It makes me angry when you're dealing with somebody like a police officer.
Yeah. You say you won't be surprised if they contact you to try and resolve it. I'll be surprised if they don't.
Yeah.
I would be very surprised if they didn't. This is common sense. People understand first responders are exposed to horrific things, and PTSD is not at all an uncommon thing for first responders to suffer from. And that's well understood. And these are people that are putting their lives, putting their physical and mental health on the line for the benefit of everybody else. The optics of that are awful for the insurance company. And hopefully, once we start a claim, it'll get in the hands of someone who understands that and understands what's really happening here and what the right thing to do is.
Having said everything you guys just said, so why would they not accept or cut him off? They're just playing the odds that he'll turtle and walk away?
Yeah.
An odds game?
Yeah,
As ludicrous as that sounds.
Well, sometimes the adjusters, are not well trained or not very experienced. Some of them are, but some aren't. And it's possible it just landed in the hands of somebody who didn't really understand what this was, who didn't have an understanding of mental health issues or the issues that are commonly faced by first responders. I mean, that's just something that happens.
The reach out 1-855-821-5900. That's the phone number anytime while we're on the show, or otherwise get a hold of James or Sivan or a member of the team. Email is help@disabilityrights.ca. First email for the show, guys, comes from Taylor. Taylor says, my wife has an alcohol addiction and is off work as a result. She gets treatments now, but she's not ready to go back to work. She applied for LTD, long-term disability, for this and was denied. I thought there was no point in appealing, so we just left it alone. But now I've listened to your show, and I want to talk to you about her case. Her therapist doesn't think that she'll be able to go back to work for a very long time. What do you think?
So first of all, Taylor, I agree with you. There is no point in appealing. I wouldn't leave it, though. I'm glad you've contacted us, and we can certainly help. What I do want to focus on here, though, is the issue of substance abuse in the LTD context, because that can be a little bit tricky. And you have to really be careful to take a look at the policy and the language in there. Typically, when we're talking about issues in long-term disability claims, there are some things that are standard that we see in almost every single LTD policy. There are a few that are outliers, but generally speaking, most group disability policies work more or less the same way. But substance abuse is something where there is some variance policy to policy, and so you want to really make sure that you look at the language carefully and understand exactly what you can and can't do when you have a substance abuse issue. What I would say for sure, in all cases, is you want to be very careful that you are following all treatment recommendations as carefully as you possibly can, especially with a substance abuse issue, because I see it all the time when people have substance abuse issues. If you deviate at all from what the recommendations are, you're going to get cut off.
Right.
Doesn't necessarily mean it's going to be justified, but they will cut you off as soon as you deviate at all from recommended treatment.
So they're just waiting to prey on that if you deviate a little bit.
Absolutely.
They will look to pounce on that. And in fact, we had a case recently where that was the issue. That was the reason why the individual was cut off, because he fell off the wagon. He wasn't able to continue with treatments. And what we did is we had a discussion with his family doctor, who deals with specifically addiction issues and alcoholism. And in that case, she provided us with a report where she explained that it's not that he was not following treatments, it's that it's part, or it's par for the course when you're dealing with substance abuse issues and cases where a person may have, ups and downs.
A bit of a relapse.
A bit of a relapse. It does not mean automatically that the person is not following treatments. You got to look in the context of the case. Right. And that's something that a lot of people, I think, are experiencing. But when they are faced with a denial by the insurance company that says you're not following treatment recommendations, and from their standpoint, they're thinking, okay, yeah, I had a relapse, I wasn't following it, they give up. And that's the worst thing you can do with an insurance company, simply give up. And not at the very least talk to us, and it doesn't cost anything to speak with us to get this information so that we can tell you you have options, right? Here's the menu of options. And if after you know those options, you decide not to pursue them, then that's your decision, absolutely. But at least find out your legal rights.
Okay, that email address again is help@disabilityrights.ca. We'll get to more of those a little later on in the show, including coming up after a short break. 5 things you must do ASAP if your LTD benefits are about to be cut off. Don't go anywhere, stick around for it. 1-855-821-5900 is the number to reach out as well. Disability Law Show. Be right back.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurance to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back to the Disability Law Show. We will get to the 5 things you must do ASAP if your LTD benefits are about to be cut off. But first, as promised, pocketemploymentlawyer.ca. This is good for you as well, right?
It's not an employment show, John, but you know what? It's important for people to know about this new thing that we created. So you know, people know that we have various websites and places you can go and ask questions. But you know, John, some people don't want to necessarily call us or email us for whatever reason. Well, we created this new tool called Pocket Employment Lawyer, so it's pocketemploymentlawyer.ca, and what it is, it's not only for individuals who have issues with their workplace rights, right? If you've been let go or you've been harassed or you know there's a constructive dismissal situation, it's also if you have a disability issue with your insurance company, you can go to this website. It's free, it's anonymous, and all you do is you input a few key pieces of information. So you select from a few options that are applicable to you, and then this Pocket Employment Lawyer tool will then give you a very basic analysis of your case. It will give you some basic answers, preliminary, a starting point, something that will allow you to then decide whether or not you want to contact us further and get more information about your case or not. It's been used, I can tell you, in the last few weeks, literally hundreds of times, not only from across Ontario and BC, but across the country. It's absolutely amazing. So it deals with disability as well as any employment issues that anyone has.
It's like having a little Savannah in your pocket at all times.
Yeah, that's it. You got it.
Digest that for a while. Pocketemploymentlawyer.ca, again, anonymous. And if you want to contact, there's a contact button at the top right, little yellow button. Okay, 5 things you must do ASAP if your LTD benefits are about to be cut off. I'm going to throw this one to you, James. You're going to do all 5. Tackle them. First one is this: check your LTD policy to determine at what age your benefits are supposed to expire.
Sure. So the vast majority of policies are going to have an expiry date of age 65.
Yep.
That's, I won't say all of them by any means. It's almost all.
Fairly standard.
That said, you want to be careful and make sure to double check, because there are policies that will extend beyond, and occasionally there are policies where it will be for a limited period of time, for 2 years, 5 years, whatever it is, after you become disabled. That, though, you should juxtapose with what an adjuster might say is 2 years you've been on the claim and therefore your claim is about to end, which is language that we hear from adjusters from time to time, or that our clients tell us adjusters are telling them. And that is usually referring to what we call the change of definition.
Right.
So in the first 2 years you're on claim, the test for disability is whether you can return to your own occupation. That test changes after 2 years and gets more difficult. And so oftentimes an adjuster will tell a claimant that their disability benefits are going to end because they're at the 2-year mark. The suggestion there being, without explicitly saying, that the policy only goes for 2 years. Yeah. But in almost all cases, it will go beyond that. So double check and make sure what the end date is, how long your benefits go to. And if they go beyond what the adjuster is telling you, then make sure you ask the adjuster, well, what are you basing that on? Show me where in the policy it says that my benefits end at this particular point in time. I see age 65.
Anytime you want to reach out, by the way, for more information, disabilityrights.ca. Number 2 on the list of things you must do ASAP if your LTD benefits are about to be cut off is this. If you're unable to work, get your doctor or doctors, for that matter, to confirm in writing that you are still disabled and explain why you can't go back to work at the present time.
So, John, I'm going to answer that. Before I go to that point, though, just one thing about the last point that you had mentioned, the age 65. Some people, when they get hired at the particular workplace, they're presented with an option, an election, as to whether or not they want to be covered for LTD for 2 years or more than that. Just be very cognizant if you are facing that choice. Sometimes you have to provide some medical information to be able to qualify beyond that date. I'm not talking about if you're denied. I'm talking about if you've just been hired.
Okay.
And your employer tells you you can get LTD coverage. Be very careful to look at those forms, because I've just dealt with a woman who inadvertently did not provide that election or provide the election, but had chosen 2 years ago to have it for 2 years, and now she's disabled and she only has 2 years worth of LTD. So just be very, very careful of that, that if you are presented with that option, that you can in fact, and you do choose the more extended version of the LTD coverage.
Cool.
Now, number 2, if you're unable to work, get your doctor or doctors to confirm in writing that you're still disabled. This is really, really important. Remember, I've said this quite a few times, and James has as well. Your doctors, in a way, are your shield, but they're also the sword that we use to go after the insurance company when they deny your claim unjustly. We need your doctors, and you need your doctors, to be in line with you, to explain to the insurance company from a medical standpoint, not just medically, by the way. We're talking about any treatment providers. You can have an OT, you can have a physiotherapist. Whoever's treating you and are saying that you are impaired or you have a functional limitation whereby because of that you cannot work, that needs to be on paper. And you need to be able to get that from your doctor or whoever's treating you and give that to the insurance company. And that is especially important when you are facing a cutoff from the insurance company. Because if the insurance company says, we're going to cut you off, and that's despite the fact that they have a recent report or reports stating that you cannot go back to work, that's going to be a problem for them. The adjuster may not realize it necessarily or may not care, but that's going to be something we're going to be relying on down the road to advance your claim, to force the insurance company to come to the table and pay you what you're owed.
Okay, number 3 on the list, guys, things you got to do ASAP if you're going to be cut off, and that is, if you haven't already done so, apply for CPP Disability.
Yeah, this is a really big and helpful thing that you can do when you're disabled. So people understand, your long-term disability benefits are paid by an insurance company, but not everybody understands that they have the right to apply for CPP Disability Benefits, and you can do that before you turn 65. The test is whether or not you have a severe and prolonged impairment that prevents you from engaging in any employment. That's the test. So it's a harder test to pass than for most LTD policies, but it's one that many people are still able to pass.
Okay.
And the benefits are up to $1,300 a month. Now, if you are also getting long-term disability from a private insurer, you're not actually going to get more money out of it. All that's going to happen is your insurer is going to get a credit. So you may be wondering, well, okay, if I'm not going to actually get the benefit of this $1,300 a month or whatever the CPP is calculated at, why should I do it?
Right.
Well, there's a very good reason for that. Number 1, you still may not be approved by your LTD insurer. Even though the test for CPP disability is harder, you still see many cases, where people are approved for CPP disability and not for LTD. So that's a very good reason in and of itself. If you're not approved for LTD, you still have that $1,300 a month coming in. But even if you are approved for LTD, if you haven't applied for CPP disability, your LTD insurer has the right to say, well, you should have applied, and because you didn't, we're entitled to take a credit for that. So not only are you not getting the credit for or getting the additional $1,300, you're actually losing that money. They can actually do that. So there's no harm in applying. Wow. And if you apply for CPP disability and you're denied, well, that's too bad for your insurer. They have to pay you the full amount. And if you're approved, it's a really good argument to use against your insurance company against cutting you off at any point in the future. If I'm approved by the government on a much harder test, how can you possibly justify cutting me off?
Yep, good call. 5 things you must do ASAP if your LTD benefits are about to be cut off. We're down to number 4, and it is this. Confirm in writing to your adjuster that you are not ready to go back to work and that your doctors have said that you can't go back to work as well.
So that's very, very important, and that's in line with, again, what we always say, which is document your communications with your adjusters in writing. It's not enough for you to simply speak with them by phone. You want to make sure that there is no ambiguity with respect to that communication, and especially when you are dealing with a situation where you are about to get cut off, or I'll extend that, just generally speaking, you want to make sure that you paper the file. In many instances, people will be contacting me after watching the show, after hearing us on the radio, and they're raising all these red flags that they're noticing from their adjuster. And I said, well, have you documented that? Have you emailed the adjuster this and that? And they said, no, we haven't.
Right.
And I tell them, you know, it's unfortunate, but here's what you need to do. You need to document that. And so in a situation like this, when they tell you they are likely going to get cut you off, or I say this, frankly, very frequently in a situation where they say you have to try to go back to work, try to go on a gradual return to work program,
right,
or we're going to cut you off. Confirm that in writing to them that they've said that, and make sure you mention why is it that you think you're not ready, if in fact you're not ready to go back to work, and what your doctors have told you about not going back to work at this point in time. So the key here is that you have to confirm this in writing. Why? Because if they cut you off, that is a contemporaneous record that we are going to be relying on down the road to make our case not only for those benefits that they owe you, but potentially for extra contractual damages, punitive damages, to punish the insurance company for doing these things despite knowing full well that you're not ready to go back to work. So it's absolutely critical that you confirm these things in writing, and you know, don't leave anything to chance. It's not about, you know, don't be tired of doing that. You know, don't just, you have to make sure that it's in writing. If it's not in writing, the adjuster will dispute it.
Even if they don't respond to it, you sent it. Still
That's
good.
great. If they don't respond to it, that's fantastic, because then
Right.
in a way you can argue that essentially they've
didn't have a
agreed to
problem
it,
with
or
it.
yeah, exactly.
Right.
Exactly.
Number 5 is this, guy. Simple. Contact us immediately and do not appeal.
Yeah, so it sounds very straightforward and
Yep.
simple. You might wonder, well, why on earth wouldn't anybody call right away and start a claim right away? And the reason is because when people are denied benefits or cut off, they're always sent a letter, and it outlines the reasons for it. Usually it's pretty vague. But at the end of the letter, there is always going to be a paragraph talking about, well, wait a minute, even though we've cut you off, it's not over yet, don't worry. There's this appeal process that you can go through. And so it's possible we could change our mind. So why don't you just send us the reasons why you think we should change our mind, maybe get another letter from the doctor telling us why your doctor thinks we should change our mind, and we'll consider it in due course. That's what they would like you to do. They're giving you a light at the end of a tunnel, but it's a false light. It's a false light. It never happens. Unless you are able to provide information that completely changes the picture, then they're not going to change their mind. And frankly, even when it does completely change the picture, they rarely will change their mind. The only thing that's going to get them to move their position in almost all cases is starting the legal process, which takes the decision-making for your case out of their hands, and that's critical, because when they no longer have control, they have to listen. They can't pretend that they can do whatever they want without any repercussions.
John, you know, one suggestion I will make, because when we get individuals contacting us every day about these kinds of claims, I can tell you 90% of the people that I come across, they've appealed and were denied. Generally, they appeal more than once even, and they get denied more than once.
Yep.
Not listeners of our show.
Well, no, some of them
They
are
know
listeners. So here's what I would tell to people out there who doubt what we say. If your adjuster is telling you or has written you that they're cutting you off or denying your claim and they invite you to appeal, contact that adjuster and ask them a simple question. How many of these appeals? What is the statistic of these appeals actually succeeding? And you're going to get one of the following answers. We don't know. We don't have information. They're not going to give you an answer. I don't even know if they have those statistics. I suspect that they do, but they would never want to share that with you, because why would they tell you that 99% of these appeals never actually amount to anything? So, you know, again, a lot of times people have to experience this, and then afterwards they come to us and say, you were right. But yes, you're right. Some of them, many of them haven't listened to the show, but some of them have. And they simply don't believe it until it happens, and they say, I wish I listened to you.
Okay, well, if you're watching out there, let me say it one more time. Don't appeal. Don't do it.
Simple. Yeah. Should you change your medication on the advice of the insurer's medical consultants? We'll tackle that when we come back. We'll take a short break. 1-855-821-5900 and disabilityrights.ca. Lots more disability law show is on the way. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to the Disability Law Show. This part, we get to another feature called mydisabilityquestions.com. If you have not used this website, guys, we've been talking about it for years. You can ask questions, leave them there. They get answered very quickly by one of these two gentlemen or a member of the team. There's actually a drop-down menu. You can search for your question. If it's there, it's been answered with a complex answer, so that's also a good resource as well. If not, leave it there. These guys will get to it. The one for today, guys, as follows. Herb writes in, says, I've been working with my doctor to find the right treatment for my condition and have started to notice a difference. My insurance adjuster's consultant suggested I switch my medication. I told them I would speak to my doctor about it, and we decided not to. They said that their psychiatric consultant disagrees and that I should be taking the medication he suggested. I refused to change my medication, and they cut me off my LTD payments. I'm confused. I never met their consultant. What am I supposed to do now?
Well, you know, John, if ever there was a case for punitive damages, this is one that I would go after. This is absolutely ludicrous. There is zero reason for Herb to change his medications given that his own doctor has said don't do it. Look, if you are told by your doctor to take a certain type of medication or to do a certain type of treatment, follow your doctor's advice. If for whatever reason you have a reaction to the medications or the physio or whatever treatments you're doing is not working, well then speak with your doctor about it. The last thing that I think an individual should do, John, is listen to the consultant, whoever that person is, or whoever it is that the insurance company has put on your case versus your own treating practitioners who really are there to help you. Remember, the consultant is being paid by the insurance company. To me, this is a major, major red flag. And for the insurance company to have done what they've done here, 100% exposes them, I think, to extra contractual damages. This is just completely unacceptable. And you know, I've seen situations, by the way, where the consultant that has provided that kind of an opinion wasn't even within the same field of expertise as the individual.
It's a weird word, consultant.
It's just, well, what does that mean?
It's not defined. It can mean whatever they want it to mean. And, you know, I'll pick up on what you were saying, Sivan. You know, when we go to mediations, I will almost always make an argument that there is exposure for extra contractual damages, punitive damages, to punish the insurer for how they've acted. And sometimes the arguments are very strong, sometimes not as much. Invariably, in almost all cases, the insurer is going to answer back, whether they believe it or not, oh, we're not going to entertain any extra contractual damages in this case. That's almost always what they're going to say. In cases like this, where they've actually inserted themselves into the treatment process against a treating doctor's advice, they're not saying that. They understand there's exposure. They're not going to agree to pay a line item that says punitive damages, but you better believe in those cases they know they have the exposure, and they're going to pay a whole lot more in benefits and future benefits in those cases because of that. So you're going to do much better in those cases where they've acted so ridiculously and irresponsibly.
So it's specifically not defined when they use the word consultant, because he had 3 of them in that note.
No, if it was a specific job, if they had specific expertise, they would tell you. They would say, Dr. So-and-so, a prominent psychiatrist.
Yep.
Exactly. But if they're not saying that, you better believe it's not. And it may be someone who went to a weekend course on it. Who knows? Or not even that. Or not even that.
Good stuff for this week, guys. We'll leave it there. You want to reach out anytime, 1-855-821-5900. It is disabilityrights.ca, the website, and the email is help@disabilityrights.ca. So we'll join you again next time on the Disability Law Show. Thank you.